Everybody see my screen?
Yes.
Okay. Does anybody have any questions, first of all, before I start, or is there an introduction that is needed?
Yeah. So let me introduce you right here, right now. So we have a couple of people logged on. So thank you everyone for hopping on, and sorry for the technical difficulty earlier this morning. But I want to introduce you to Ash. He is a defense attorney, and he specializes in PAGA and class action suits. He actually helped me out with one of my clients earlier this year, and he does nothing but amazing work. His whole specialty is class action and PAGA. And I'll let Ash talk more about himself and what he does to introduce everybody else.
Sure. Thanks for that introduction, Rocio. So I am an employment defense attorney. All I've done is employment law for the last 15 years, and I've only represented corporations, and I only do employment law. This is my world. I live it day in and day out. In addition to class action, PAGA stuff, I do single plaintiffs, so wrongful termination, discrimination, harassment, you name it. If it deals with employees, I do it. And so that's a good segue to discuss why I'm here. There's some stats on the bottom of this, and I'm going to go through it with you. In the last 12 months, about 7,500 lawsuits were filed, only dealing with employment lawsuits. In the last 24 months, about 9,500 class and PAGA actions were filed just in California. In the last week, 31 lawsuits have been filed just dealing with employment law issues. The highest settlement to date in California was in November, and that was a verdict for $41 million. In class and PAGA settlements, that amount has reached the billions. And in the last 13 to 48 months, you'll see a case that started this week. That's when it'll end, in 13 to 48 months. So this is a long, drawn-out process. And the goal here is to help everybody avoid both a verdict and a long, drawn-out process. I'm happy to ask questions or answer questions along the way. I see some Q&As here. Okay. Rocio, can you answer, or can you be in charge of the Q&A, or should I do that?
Yeah, no, I'll be in charge of the Q&A.
Okay. All right. So what's the first thing that we do to avoid class action and PAGA lawsuits? Well, we have arbitration agreements. What is an arbitration agreement? An arbitration agreement is an agreement where the employee agrees not to file a lawsuit in superior court and waives their right to a jury. Why is that important? Juries make emotional decisions. They make decisions that amount to $41 million. We don't want to be in front of a jury when we have a bad case or bad optics. Arbitration is a private setting. It has a private person there deciding the outcome of the case. It's generally less time consuming and sometimes less expensive. Now, can you just Google an arbitration agreement? The answer is no. The arbitration agreement needs to be very specific. It needs to include class and PAGA waivers. It needs to be presented as a standalone document. It can't be in your employee handbook. And it should be signed vis-a-vis a wet signature, because what's happening now is you have a lot of plaintiffs' attorneys who are saying that their client never signed the document because it was an electronic signature, and their electronic signature doesn't match their wet signature. So our best practice that we advise our clients is to get wet signatures. Any questions on that? Nope. So what's the next thing that we can do to avoid PAGA, class, and lawsuits in general? So PAGA is going through a reform right now. And in that reform, the statute basically says that employers who audit their records and have compliant policies will get a substantially reduced reduction if there's any penalty. Currently, the penalty is $100 per pay period per employee. This amount could be reduced up to $30 if an employer has compliant policies and procedures. So where's the first place that we start to avoid these PAGA class action lawsuits? Is our handbook. Now, there are certain things that are required in every handbook. Those things are drug and alcohol testing. They're a EEOC disclosure, a prohibition against harassment and discrimination, a clause which identifies hours worked, policies concerning leave, pregnancy leave, sick leave, and lactation accommodations. I can tell you that a lot of employers in the construction industry, they don't have a lactation accommodation policy, and that in and of itself is a violation of the California law. So I would encourage all the construction companies out there to immediately get this in their handbook. Now, what are some policies which are recommended in the employee handbook? Well, a statement that says every employee is at will, an acknowledgement that the employee received the handbook. We want compliant meal period policies in there, rest period policies, wage statement policies. We want to identify, again, the hours of work. We want to tell the employees the amounts that they would receive if they worked overtime and when overtime is triggered. It's super imperative to have a handbook. It's required by California law. And now it could substantially help reduce your PAGA penalties if you ever get with a PAGA lawsuit. Any questions on that? I see one.
Yeah, they have one question saying, will the PPT be shared?
I'm happy to circulate it. But I can tell you that things that are coming out of my mouth are not in this PowerPoint. So I would try to take notes on what I'm saying. And I can leave my contact details for you if you want answers or need any questions answered to any of your follow-ups. But yes, you can have the PowerPoint. All right, so how do you avoid, again, litigation in general? So here's what happens. You have a disgruntled employee who's wrongfully terminated. That employee goes to see an attorney and tells the attorney, hey, I want to sue my employer because I believe I was wrongfully terminated. The attorney hears their story and says, I don't think you were wrongfully terminated, but let me see your time and payroll records. What they will do is sniff out a way to sue an employer. And so what are these attorneys looking for? They're looking for time records. In the construction industry, all too often what happens is we're just writing in 8 to 5, 8 to 5, 8 to 5. Everything is very rounded. And by definition, those records are not accurate. Because I don't know about you, but although I'm a creature of habit, I never show up to work exactly at 8 o'clock. It's 7:57, 7:58, 8:01, 8:02. The law in California says every employer, you need to keep accurate time and payroll records. So by definition, when you have a time record that has 8 to 5, 8 to 5, 8 to 5, those records are not accurate. So that means then it's the employee who says, or can say, I worked these hours outside of these time frames, and now the employer, it's your burden to demonstrate that they actually didn't work the 8 hours that they're claiming. And that's tough to do when you're not keeping accurate time and payroll records. So what else is happening in the construction industry? Employees are not tracking their meal periods. They're just not. They're not punching in and out for meal periods. Or they're taking it less than 30 minutes, or they're taking it after the 5th hour work. Or what's happening is the entire workforce shuts down and we have everybody punch out at the same time. And inevitably you have the employee saying, well, wait a second. I never clocked out, right? And so we now have to prove that they took a compliant meal period. What else is missing? Well, in the construction industry, sometimes it's hard to take a rest break. Sometimes it's not so hard. And so how do we prove that our employees are taking rest periods? Well, we can track them, but that gets pretty painful. So what other ways can we acknowledge that employees are taking their rest periods? Well, we can have attestations. And so what we do for our clients is after every payroll period or after every punch, we create some language that the employee has to endorse saying that they were authorized and permitted to take both compliant meal breaks and compliant rest breaks. So after the attorney looks at the time records, what are they looking at next? They're looking at the payroll stub. The payroll stub has to have like 8 or 9 items. If one of those items is not on the payroll stub, that's a violation. It's $50 for the first violation, $100 for every subsequent violation, up to a maximum of $4,000. And what types of things do you need on the payroll stub? Well, you need the legal name of the business. It can't be a DBA. You need the hours worked. You need the compensation rate. You need the employee's identifying information, such as social security number, first and last name. It's really easy to omit this information, but that's what the attorneys are looking for when they're deciding on whether or not they should move forward with a lawsuit and determining whether it should be a class action lawsuit or a PAGA lawsuit. And one thing that I forgot to mention is when you have an arbitration agreement, you can waive the ability for an employee to bring a class action lawsuit. That is huge. You can avoid class action lawsuits just by having an arbitration agreement. I see another question here. As a staffing recruiting agency, we utilize manual timesheets to track employees' payroll hours, including time in, lunch out, lunch in, and lunch out. Yes, you should absolutely go away from that. Why? Because you have to ask yourself, is everybody actually coming in at 8? Is everybody actually leaving at 5? Is everybody actually taking their lunch at 12? I can bet you that 99% of the time the answer is going to be no. And so your records in and of themselves are inaccurate, which means now, as the employer, you have the burden to demonstrate what the true hours worked were. That was a good question, Jorge. Okay. I see another question. 5. No. Are GPS time tracking solutions defendable? The short answer is yes, but you need policies and practices in place which don't track employees when they're doing private things. So unless you have a policy and practice in place identifying when employees are and their time is being tracked, it's probably going to be unlawful. Another good question. Okay. So how do you avoid lawsuits? Documentation. I can't tell you how many times I see an employer saying, I want to terminate my employee, and I ask them why, and they say, well, they've been a bad employee, they've had tons of performance issues, and I say, sweet, show me the records, and they don't have anything. Why does that matter? Last week, the employee said that they were pregnant. I want you guys to all imagine terminating a pregnant employee 1 week after she's telling you she's pregnant. You're going to be demolished in front of a jury because all the jury is going to hear is that you terminated a pregnant employee, not that she had performance issues. So I can't stress enough how important it is to document everything. Document absences. Document leaves of absences. Document performance. Document insubordination. You can't go wrong with documentation. The more documentation, the better. You should almost anticipate that when you're terminating an employee, that employee is going to sue you. In California, as much as I hate to say this, it's not a matter of if you're going to be sued, it's a matter of when. And so you need to be prepared for that when. Every termination you make should be supported by evidence. Any questions on that? I see none. Next. So here's the low-hanging fruit for an employer and an employee and a employee's attorney. Typically, we think that we need to grant employees leaves of absence only if they qualify for FMLA or they have a workers' comp injury. That's not the case. In California, there's something called the Fair Employment and Housing Act that requires an employer to accommodate an employee anytime they have any sort of disability. It could be a work-related disability, or it could be a disability that they obtain outside of work, or an injury that they suffer outside of work. We have a duty as an employer to do what we can to accommodate that employee. That could mean providing them light duty work. That could mean providing them modified job duties. That could mean just providing them a leave of absence. We need to conduct what's called a good faith interactive process, and that process needs to be documented. What that process is basically a discussion that we have with our employees in which we say, tell me what you can't do, letting them know what their job duties are, and finding out if there's a way that we can accommodate their work restrictions. I can't tell you that this is sort of a eyesore for most employers. 80 to 90% of the employment lawsuits out there are for disability discrimination because we fail to accommodate. I don't want any of you guys being one of those statistics. Any questions there? Seeing none? All right. So we don't always have to terminate employees. We can also provide them severance. We can provide them other ways. There's other ways to get rid of employees. And I would encourage you to consider other ways to get rid of employees, particularly when there's a situation where I term it, there's red flags. So for example, if the employee is over 40 years old, if the employee is pregnant, if the employee recently had an injury, if the employee complained about any sort of work-related activity, we want to be mindful in those situations on whether we should terminate the employee. Because in California, there's a presumption. And that presumption is if somebody has a protected activity and they engage in that protected activity, and we terminate them within 90 days of that protected activity, the court's going to assume that we terminated them because they engage in that protected activity. So it's very careful. I would encourage all my clients to be very careful when deciding to terminate employees. There's other ways we can get rid of them, and that includes severance agreements. Any questions there? No? Moving on. All right. So how do you protect yourself when you are being sued? Many clients don't have what's called EPLI insurance. EPLI insurance is very helpful. You don't always have to use it, but it is helpful. It doesn't cover wage and hour claims, which is why you need to really have compliant policies and procedures, including timekeeping. But it will help you when an employee is complaining that they were wrongfully terminated. The way it'll help you is that you can use this insurance to help cover both the cost of defense and any settlement that comes out of that. EPLI insurance varies, the brokers vary, the coverage varies, and sometimes the deductibles vary. Sometimes it's as low as $5,000, up to 500 grand. So depending on your risk tolerance, you can buy EPLI policy accordingly. Any questions there? So I told you guys that most of these lawsuits happen, particularly wage and hour PAGA, is when an employee goes to an attorney and the attorney says, tell me why you're here. I was wrongfully terminated. You know why that employee goes to that attorney is because somebody contests their unemployment. If you know that there's a red flag employee, don't contest their unemployment. Because when you do, that just makes them more pissed off. And that's when they start to seek an attorney. And that's when the attorney starts asking them questions. And that's when we have to pour over our time and payroll records. So consider whether or not you really want to contest unemployment when that time comes. I see a question here. I see two questions here. EPLI protects the employer in the event of a PAGA lawsuit. No, it doesn't. Okay. Some EPLI, I would say most EPLI coverage does not cover PAGA and class action lawsuits. Sometimes you have a supplement in which they cover just the defense, but that supplement is like $250,000. So what that means is after you incur $250,000 in fees in defending the case, then they'll cover the cost after that, but any settlement they're not going to cover. Good question. EPLI wage and hour exclusion in California. Any other remedy? Yes. Depending on the claims, you can argue that they're not wage and hour claims. So the secret sauce is, for example, when you see a reimbursement claim, arguably that's a tort claim and not a wage and hour claim, and you can pierce the EPLI policy to get coverage. You heard that from me. I'm not sure many attorneys are seeking that route, but that's an option. Another option, though, if you don't have EPLI coverage, is again going through 1 through 9, which is having compliant policies and procedures, which is having an arbitration agreement. It is the easiest thing that you can do outside of getting an EPLI policy. or just for something like wrongful termination, etc.? Jorge, I'm not following your question there. So I'll leave that. Why would an employer contest? Well, easy, right? Because generally employees are not permitted to get unemployment if they were terminated. They only get unemployment insurance and benefits when they were laid off. And so most employers contest employment when their employees are terminated because they don't want their employees seeking additional benefits. Good question there. EPLI coverage comment for law firm employers. How do you find out coverage? I'm not sure I understand that question. So maybe you can reword the question. In the interim, I'll move on to the next slide. So as we're in the midst of the PAGA reform, one of the things that you need to do to get those reduced penalties is train and educate your employees. You train them on meal period policies, rest period policies, not working off the clock, anti-retaliation, anti-discrimination. You tell them that we're going to accommodate. You provide open door policies and practices for them to do that. Any questions there? Nope. Here's the last thing that I would say. A lot of employers are only reaching out to attorneys when there's a lawsuit. I specialize in preventative measures. What does that mean? Call me, have a 5-minute conversation with me, and we can circumvent issues that cost $50,000 to $500,000. That 5-minute call I might charge you a few dollars. It's not expensive to seek advice and counsel. And a lot of times, that's the easiest way to prevent these lawsuits. Any other questions? I'm a fast talker, so I'm happy to repeat anything and or everything or answer any other questions. And I don't know if there's a way to go live to have people ask questions, but I leave that to Rocio.
Yeah, let me make myself the host because there is a way to do that. So let me make myself the host right now so we could have people jump in and start asking questions. Dun, dun, dun. All right. All right, someone's asking, do you handle all California or does jurisdiction matter?
Anything in California, I handle. Anything related to employment, I handle.
Let's go. All right, so Michael's asking regarding employees on medical leave who exhausted 12 weeks FMLA and after providing the ADA and they had been being for around 6 months, what is the next regarding the employees on medical leave who exhausted 12 weeks of FMLA and after providing...
I see that all the time. Automatically employers say to themselves, well, they exhausted their leave, 12 weeks is up, I can terminate. The answer is no, can't. You need to go through what's called the Fair Employment and Housing process, and you need to engage in the interactive process to determine whether or not you can accommodate the employee through a continued leave of absence, unless doing so would be an undue burden. And you got to document that process. What I do is I provide all my clients with the interactive process worksheet. That worksheet is the evidence that you need to demonstrate that you engage the employee in an interactive process to accommodate them. This worksheet requires both the employee to do something and the employer to do something. And when you finish the end of the worksheet, it'll tell you whether or not that employee could be accommodated or not be accommodated. So, in short, the FIHA doesn't have any time limits.
Okay, there you go. All right, we could the viewers can now ask questions versus the chat. Sorry about that. Thing was going, but people are free to ask questions. And then I have another question over here. Is there any coverage, any type of coverage that an employer can purchase to protect against a PAGA lawsuit?
You have to check with that EPLI carrier. But again, in California, insurance companies are just not going to cover wage and hour. They will cover the defense of it sometimes, but it's going to be subject to a sublimit. And that sublimit is going to be really high. The easy solution is an arbitration agreement. Because an arbitration agreement, what that would do is prevent the employee from bringing a PAGA lawsuit. The employee, what they're going to have to do first is prove that they suffered violations before they can bring a PAGA lawsuit. And again, that arbitration agreement entirely waives class actions. And so here's the misnomer. Everybody's afraid of PAGA. You know what's more scary than PAGA? Class action lawsuits. And let me tell you why. PAGA, the statute of limitations is 1 year. A class action lawsuit, statute of limitations is 4 years. So before you're worried about PAGA, I would worry about class actions. And you can entirely waive class actions through an arbitration agreement.
Says, how familiar are you with PEO staffing?
1,000% familiar.
Yeah, that's what you specialize in, don't you, in staffing?
I do anything employment related.
And then we have a question from Adam. If SB 92 and AB 2288 pass, how will it change the current regulation?
Look, just like you guys are probably going to have to Google SB whatever. Can you tell me what that is?
SB 92. Let's see. SB.
While Rosie's looking that up, I have a question for everybody. And maybe you could just raise your hand. I don't know if there's that option. How many of you are employers? How many of you own your own business? Okay. How many of you, oh wow. So the majority of the people here. And of the people raising your hands, keep your hands raised. How many of you have arbitration agreements? Okay. Now, of the one person that has the arbitration agreement, has it been updated in the last 2 years? Okay. Does it have both a class and PAGA waiver? So nobody has that. And that's the cheapest, quickest thing that you can do to avoid class and PAGA lawsuits.
You just said there's a PAGA waiver?
Yeah, so the way the way arbitration works for PAGA is it doesn't waive PAGA altogether, but it requires the employee first to prove that they suffered violations. Only after they prove that they suffered violations can they move forward with their PAGA action. And how it works different with class actions is you can entirely waive a class action. Class actions are much more expensive than PAGA.
And why are class actions more expensive than PAGA?
Because they go back 4 years.
Okay.
And so there's 4 years of statutory penalties for both current and former employees.
No.
PAGA, remember the cap is $100 per penalty. And if you go through an audit, and if you have these policies, you can reduce that between $15 and $30. And you're capped at 1 year. So we're looking at a few $100,000 as opposed to a few million.
Wow. All right, so we have a second question here from George. Going back to the timekeeping question, if we go to digital timekeeping method, where employees need to download an app to clock in, do we need to reimburse the employee for phone usage?
Yes. You have to reimburse employees for all business-related expenses. And at our firm, we promote a timekeeping system, which also has attestations built in. And so we're using it as a one-stop shop for employers to demonstrate that they're complying with California's wage and hour laws. And so the way the system works is before the employee can clock out for the day, they have to answer 3 questions. The first question is, were you authorized and permitted to take a compliant meal and rest period? The second question is, if you were not authorized and permitted to take a compliant meal and rest period, why? And to confirm that they didn't work off the clock. That is an employer's evidence that they complied with California's wage and hour laws. And it costs nothing to do that.
All right, so this question is from Michael. Employees on medical leave then can be on leave for an infinite period of time. In my case, I have employees who are on leave for 6 or 7 months already.
So the law in California is if it's a leave of indefinite nature, you don't have to accommodate it. But if it's not indefinite, you need to accommodate it unless it would create an undue burden. So what's an undue burden? It usually goes, it falls back to financial. What is the financial strain on the employer to keep the employee on the leave of absence? So arguably, for example, you have allowed this employee to take 6 months leave of absence. What's another month? What if the employee says, I need another 2 months? Is that unreasonable? Is that going to cause an undue burden? Well, it depends, right? And that's what we do when we evaluate accommodation issues as an attorney. We provide the advice and counsel on that and can help the employer determine what next steps to take.
Okay. And then George is asking, how can we get that waiver?
You can call my office.
And then someone else said, is it legal to provide a PAGA waiver?
There was this Viking decision that came out, and it basically says you can't waive PAGA altogether, but what you can do is require the plaintiff to first prove that he suffered or she suffered the violations before moving forward with his or her PAGA claims.
Got it. And then we have a question from Nicole Corey, work comp case. The employee has been out over a year. His role has been backfilled. We just received the QME report that he is released to full duty. Can I legally not bring him back to work since his job has been filled?
Short answer is no. And I just resolved the case for $80,000 over that.
Mm. And then a question from Scott, is alternate dispute resolution going to become more available to California employers?
That's what arbitration is, essentially. So yeah, it's available to employers if you have arbitration agreements. If you don't, it's not. Here's another question for the group. Has anyone have any experience with litigation? So nobody in this group has ever been, oh, Chris. Chris, I'm going to ask you to, if you can, and if you're amenable to it, unmute yourself and just tell us what your experience was. Is Chris able to unmute himself, Rocio?
Yes.
Chris, do you want to unmute yourself? That's okay. Litigation is not only time consuming and expensive, but it's stressful. I'm sure, Chris, if you would agree, was litigation stressful for you? You could just raise your hand. Chris raised his hand. It's stressful not only on you personally, but it takes a toll on your business. It takes a toll on your employees. It's exhausting. You don't want to go through it. So I encourage everyone in California, seek preemptive advice because it's just cheaper. It takes minutes and it's less time consuming and costly. Chris, is that litigation still going? If it is, you can keep your hand up or bring it down. It sounds like that litigation is still ongoing. Chris, has it been more than a year? If the answer is yes, keep your hands up. And if the answer is no, put it down. Has it been more than 2 years? Your hand's still up. Has it been more than 3 years? Wow, so 2 years. That is the average length of litigation.
Wow. I mean, I could go off the, pinpoint to that fact that it is super expensive. I mean, going through the whole litigation process and bullying from, the applicant and attorney, it's just, I mean, I've seen it firsthand with my clients. It's scary, especially if they don't have EPLI, because some of those lawsuits will include, wrongful termination, but then they will include, meal breaks, missed lunches, not paid on time, gas reimbursement.
And you know what? I don't know if I'm necessarily a big proponent of EPLI. And the reason is when you have EPLI insurance, your EPLI carrier is going to send you to an attorney who just does insurance work. And inevitably, that attorney is driven by the insurance carrier. Their goal is to hit the deductible and get as much, generally speaking, as they can, and then try to resolve the case after they hit their numbers. And here's another dirty little secret that I can tell you. A lot of lawsuits start from workers' comp. What do I mean by that? That attorney, that applicant is going to have a workers' comp attorney. We're going to terminate that employee. And that attorney then is going to refer to an employment attorney. And that's how you have your disability discrimination lawsuits. That's how you have your wage and hour lawsuits. That's how you have your PAGA lawsuits. Most referrals come from workers' comp attorneys.
Yeah, I mean, you're right on the point right there. A lot of those claims stem from workers' comp. There was some type of retaliation issue, or they were laid off and they decided to do the cumulative trauma, and then they decided to add on the rest of the wage and hour.
I see some more questions here because I don't know if anybody is able to talk. What is your contact information? Is there a way to post that, Rocio?
Yes. And I'm also going to send an email afterwards, but do you want me to just put it on the chat?
Sure.
Oh, there's Adam. I'll put it in the chat right now. Let's see this.
Hey, Ash, can you hear me?
Yeah.
Yes.
A quick question: Is there an amount of time an employee need? I've heard these horror stories of an employee working for your business for 1 day, 2 days, 1 week, and then making a claim like this. Is there any minimum amount of time an employee needs to work somewhere?
No, I have a case right now. I have 2 cases right now in which, and I can't tell you who the employer is, but let's say it's a large national chain. They decided during the interview process not to hire the employee. And the employee, even though she wasn't hired, is suing for discrimination. Conversely, I have an employee who was there for 2 months, was terminated for performance, and now is saying she was terminated wrongfully because she was a whistleblower, and we're terminating her because she's a whistleblower. And their opening demand is $700,000. The whistleblower cases, I don't know, Adam, if you were here when I first started, whistleblower cases are very emotional, and they trigger one of the higher jury verdicts, along with sexual battery, sexual abuse, sexual harassment. The November verdict for $41 million against Kaiser was a whistleblowing case.
Wow.
Good question, Adam.
And one other question: if you've been in litigation with regards to those attestations that come on the daily clock in and clock out, do those prove to be beneficial during litigation?
Yes, and I'll tell you exactly how. 2 weeks ago, I represent another national retail chain in which the employee requested time and payroll records, insinuating that they were going to bring a class PAGA lawsuit. We responded not only with the time and payroll records, but with the attestations. And then I followed up with, let's have a call to discuss. And the attorney said, you know what, for this case, we're going to leave it alone. Because the evidence was there.
Okay, so it seems like that one of the solutions to this as a small business is the time and payroll records, and then in addition, the arbitration agreement, PAGA waiver, and then attempt to severance when someone leaves. I guess with the goal of, if they ever go to an attorney, the attorney's going to look at it and say that this is way more work than it's worth.
That's right. And there's so many defenses that I got to deal with that I might not win. And it's important. So let's talk about the attestations. Typically, and usually this happens in the construction industry, we have this generic punch in and punch out form. And at the bottom of the form, it says, like, I swear that I worked these hours, right? Or we make them sign that kind of attestation before we give them the payroll check. 99% of the time, the plaintiff's attorney that says that says the following: you made them sign this document, otherwise they wouldn't get their payroll check. So it almost means nothing. And so what we do at our firm is we have a process by which we disclose and require our employees to complete attestations, so we're not dealing with those arguments. And another thing, Adam, that I would do, now that you mentioned it, is I have a checklist. Before my clients call me and say, I'm going to terminate, John Smith, I say, first, give me the documentation supporting why you're going to terminate. But also, let me see their time and payroll records. Let me just audit it, right? Because when I have to inevitably produce these documents, I don't want anything showing up which would raise a hair on that employee's attorney's head so that they can file any sort of lawsuit.
And you mentioned that earlier about an audit. If you go through or audit the payroll records, you can reduce fines from 100 down to 15 or 30 per incident. When you say audit, is that a self-performed audit? Is that can you explain that audit?
Yeah, so the legislation is just coming out and it should be finalized within the next week or two. I don't know if it's going to have any definitions, but unless you're sort of proficient in employment law, I don't think doing a self-audit is going to help you defend yourself. You're going to have someone or some entity who's proficient conduct that audit. to sort of give you this certificate saying, yes, I went through this audit. I can see that you're complying with California's, meal and rest periods. And I think you can use that certificate and the audit results to demonstrate that you're doing the due diligence required to comply with California law. And therefore, to the extent there is a violation, your penalty should be reduced from $15 to $30.
Hey, Ash, this is Scott. Can that audit be done by your payroll provider, somebody within that company, or does it have to be a third-party audit?
Again, there's no certainty. The legislation is not identifying what that audit would look like. But if your payroll provider is proficient in doing these things, that could be one way of getting around it. But your payroll provider is not going to look at your policies. What they're just going to look at is your time records and your payroll records.
Right. Most payroll companies are selling HR along with their payroll, right? These days, they're trying to couple that. So it gets really, really sketchy.
Yeah. And usually what you have when you, like, for example, ADP does that. You're just speaking with an HR representative and you'll call them on Monday and they'll respond to you on Thursday. And the goal of ADPs, and I don't mean to, throw ADP under the bus, but most of these providers, they're more concerned with you being sued than helping you run a business. And at the end of the day, you're running a business. So you want to accomplish your goals in a legal way, not accomplish your goals by simply not doing something because you're afraid of being sued. That's not my mentality. That's not our firm's mentality. We want to let you run your business, and we'll figure out a way to accomplish what you want by allowing you to run your business and mitigating any litigation exposure. So, for example, if I see that you want to terminate somebody and there's a red flag to me, we'll figure out a way to get rid of it.
So in that instance, especially in the construction trade, is providing less hours and telling an employee maybe you're not busy enough to keep them working 40 hours a week to try to persuade them to go to another job or do a volunteer.
Chick-fil-A has done that, and it's worked for Chick-fil-A. But I can tell you that there was a recent decision out of the Supreme Court that says if you're reducing somebody's hours, that could be tantamount to what's called an adverse employment action, and just the reduction of hours may be sufficient for them to bring a lawsuit.
One more, Ash. So you bring on a new employee and a month later he files a work comp claim and you find out that he's filed multiple claims from multiple employers, which, as we all probably know, maybe we don't, that you can't check that out before you hire that individual. But after the fact, you find out that this is a professional claimant. What's the best way to go about that?
I am happy to give you that advice off the record, because my advice would be off the record advice.
Yeah, no, I get it. Thank you.
And then Ash, one more question. This is Adam again. With regards to having employees sign the 6 hour or less workday lunch waiver, and then having them sign the second lunch break less than 12-hour worked waiver, I've heard kind of conflicting advice on whether to have employees sign that, because it can be looked at from the plaintiff's attorney as it was forced. And instead of that, just having them, signing a handbook that says they understand the meal and rest break policy. Do you have any input on one or the other?
I have no issue with waivers. I've never had a challenge when my employers have required employees to sign waivers.
Okay.
But that certainly doesn't alleviate you from having compliant meal and rest period policies. It always starts with the policy. That's your first line of defense. And then it gets into the practice.
Okay. And then is your recommendation from what you've seen? I know there's these third-party HR companies that someone else mentioned a lot of times are partnered or a sister company of payroll companies, and then there's third-party HR companies that are independent. As far as employee handbooks, for the state of California. Does your firm, and do you recommend in general that your handbook in the state of California for an employer is written by an attorney or a law firm versus these HR companies?
So I will tell you advice as it gets my interest. There's a website called Cal Chambers. It's like $500. Just get your handbook from there. There's going to be a series of prompts that you have to go through, which is going to be time consuming, but it's a lot cheaper. So the short answer is you don't have to go through an attorney, but just make sure your handbook is legitimate. And there is a legitimate handbook on the Cal Chambers website. You just have to go through the prompts. And it might take you 2 or 3 hours to finish.
Right.
And that's why sometimes employers, they just don't want to deal with the time. They just want a handbook that's populated, and an attorney is good for that. But these HR companies, and I haven't seen one, maybe they may do a good job. I couldn't tell you, but I can guarantee you that if an employment attorney does it, it's more likely to be accurate.
Mm-hmm. Thank you.
Yep.
Hey, Ash, what are you charging for a handbook? Depending on the business.
It's expensive.
Ballpark.
Which is why I don't even try to sell it. It's around $2,500.
Yeah, $3,000. Okay.
The good thing about that, though, is I think on an annual basis, there's like an hourly rate to update it. So $400 there afterwards. And depending on the size of your business, the handbook could be, as cheap as $800.
Yeah, the SHRM version's good, right? But it's a boilerplate. I think it's important for employers to reach out to professionals like you to articulate the different kind of challenges, because every operation is different. It's a great point. Yeah. It's well worth the money spent for sure.
Yeah.
We have a question from George Ash. So, question regarding salaried employees. If someone has a base salary of $8,500 a year with the expectation of working about 45 hours a week, then they go a couple of weeks working 20 to 25 hours, can that salary be reduced?
But I think the better question is this person properly classified as an exempt employee so that they are receiving a salary? Many times in California, we pay salaries to people that shouldn't be earning a salary. Here's an example. Say you have a store manager at Ralph's, and that store manager at Ralph's is at the check stand for 8 hours a day. That store manager, who's supposed to be an exempt employee, during the period that they're on the cash register, they're performing non-exempt duties. And therefore, if they're being paid a salary, during that occasion, they're going to be deemed misclassified as exempt, and you're going to have to pay them overtime for every hour worked over 8. And for every lunch they didn't take, you're going to have to pay that premium.
A great point. Especially now, with a lot of employees working remote and from home. I've actually received a lot of questions about that from my own clients, asking like, hey, this person's, salary, but she's taking a couple of days off, and, it's kind of here and there.
If somebody works 1 hour during the week, they're entitled to their salary.
Fuck.
Hey,
I don't know, Marcio, if you put my contact information in the chat.
Yes, it's in the chat, and I answered it to
I
one
see
of the
it.
questions.
I see it. I'm going to go out on a limb and give everybody my cell phone because I almost never answer my office line. All my clients call my cell, and they like the feeling that I'm going to answer no matter where I am and what I'm doing. So if you guys want to take it down, it's 562-760-8803.
Is that hourglass going to start turning the minute we call you, Ash?
Not unless you retain me.
I was just messing a little bit.
Yeah. This surprises people, but those employers who call seeking advice and counsel, it's not that expensive. It could be $1,500 for the whole year versus 150,000, right? And we've had several of those situations where we've circumvented a lawsuit through a 5-minute call. And I build my practice not just on being an attorney. Like, my goal is to be business partners with my clients. We're partnering together to help them achieve success.
Did a good job, Ash.
I appreciate that.
Great information. Thank you.
Here's a dirty secret. My wife prepared this PowerPoint through OpenAI in like 4 minutes after I told her the 10 things that I wanted to talk about.
That was a good PowerPoint.
Yeah. It's pretty accurate too. And so on that note, I've actually tried OpenAI to do an arbitration agreement. It's almost there, but it's not. And so I would caution every employer out there that OpenAI, I think its latest, it's like up to date until 2019. So after that, it's not up to date on the legal issues. So while you can use Google and OpenAI to get a lot of these things, just know that it's probably not going to be up to date. And why is that a problem? If the case law has changed and you're using clauses which are now unenforceable, you just invited liability.
Okay, we have one last question, Ash. Can you please clarify when an employee is on a medical leave for more than 3 months, can the employer seize the employee's benefits after 90 days?
That depends on the benefit plan.
Okay.
So hearing or seeing no more questions, I'm going to expect everyone in this chat to go get an arbitration agreement today, whether it's through me or someone else. But if you don't do that, you're essentially committing malpractice as an employer or somebody who's helping employers. Get the arbitration agreement.
Thank you, Rosia, for putting this together. Ash, again, you did a great job, man.
Appreciate that.
Yeah, no, thank you so much, Ash. I appreciate you joining this webinar. There's actually one of the most asked questions about, class action, PAGA, wage and hour. I mean, that's every employer's nightmare. So I really appreciate you, being on this webinar for an hour and allowing my network and clients to ask you questions and everybody that decided to join.
Sure, you got it. Well, I'm here if anybody needs me.
Yeah. So everyone, this is recorded and this will be made available, and I will also be sending out an email and CCing Ash to those who attended. Feel free to reach out to Ash. As I mentioned, Ash is a very great defense attorney, and he's, as you all can see, he's very knowledgeable. And I just want to be able to provide you guys with resources. And like Ash said, reach out to him before you guys get the lawsuit.
Yeah, avoid the lawsuit. Okay, take care, everyone. It was nice hearing and getting comments and questions from everyone.
Sounds good.
Thanks again.
All right, thank you, everyone. And we'll be sending out an email shortly. Have a nice day.